Good afternoon, everyone. I'm Matt Crowley, Chief Operating Officer here at the Florida Medical Association. Welcome to today's CME webinar on healthcare law. Our presenters today are Sarah, Senior Attorney with Chapman Law Group based in Sarasota. Her career is dedicated to defending healthcare professionals whose licenses could be suspended or revoked. Juan Santos is Senior Healthcare Compliance Attorney at the Chapman Law Group's Miami office. His vast knowledge of healthcare law and his role as a medical compliance lawyer allows him to handle virtually all issues facing the modern healthcare professional. And with that, I think Juan is going to be presenting first today. So with that, Juan, I'm turning it over to you.
Thank you very much. Good afternoon. My name is Attorney Juan Santos. I work on the Corporate and Compliance Department of the firm of Chapman Law Group. And I'm going to be talking to you today regarding the government audits and when you bill Medicare or private insurance. So in healthcare, like I tell my clients, there's two separate businesses that are completely different. One, when you're dealing with cash pay. Second, when you're billing a third-party payer, Medicare, Medicaid, and private insurance. The reason why is that when you bill Medicare and Medicaid, you are receiving taxpayer money. So all of the laws, such as you probably heard of, Stark Law, anti-kickback, fee splitting, many laws that normally wouldn't apply when you're talking about a cash transaction, the patient paying you directly, apply when you're taking money from the government. The same is said to private insurance. There's laws at the state level that protect private insurance from providers or anybody trying to do some type of fraud or anti-kickback, etc. But most importantly is that when you bill under a code, a CPT code. And that code basically that you're billing under has what are known as conditions of payment, requirements that Medicare, Medicaid, or the insurance companies have stated that you need to meet or the patient needs to meet so that the payer, Medicare, Medicaid, or private insurer will pay for the service. So those are basically what is known as medical necessity. And normally it comes down to your medical records and that your records obviously are pristine and are as good as they can be. CMS issues what are known as national coverage determinations, which at the national level, CMS would say, hey, if you want to get an MRI, the patient needs to meet all of these requirements. Those requirements are done at the national level, which are called NCDs, and also Medicare works with private companies. They're called contractors. Some of them you might heard of if you've been audited, First Coast, Safeguard, Noridian, CGS. So many of them, depending on the area where you are located, those contractors are in charge of providing audits. They also can issue what are known as local coverage determinations, so LCDs. So along with the national coverage, the MACs can issue local coverage determination that can add more requirements or can be more flexible and have less requirements. So we're going to talk about how this process works when you get audited and basically where the risk lies. Florida is known as the capital of healthcare fraud. And many people think that it's all up because we're stealing money or the providers are basically overbilling for services they're not rendering. But many times it's not the case. Many times we're talking about the anti-kickback, whereby the service was provided, the patient got the service, but the way the patient was recruited violated this law, and that becomes a federal crime. It can be penalized with 5 years in prison, and you can have penalties of $250,000. However, there are exceptions to the law. Again, they're called safe harbors. Some of them are the bona fide employee safe harbor, where if you employ as a W-2 bona fide employee, and those have 13 factors that you have to take a look at, then you can pay that employee commissions for bringing business. And then you have the Stark Law. The Stark Law only applies to providers. The Stark Law is when a provider that is in a position to refer, self-referred, what is known as a DHS, a designated health service, that he has a financial interest in that other company that he's self-referring. So the clear example is you're a radiologist and you have your own MRI center and you self-refer to that MRI center, having equity or a family member having equity in that MRI center. There are a lot of exceptions to Stark also. So don't think because it may violate Stark, it doesn't mean that we can try to fit the arrangement or the business model in one of those exceptions. In healthcare, the people that are going to investigate providers, first and foremost, normally is going to be the OIG, which is the Office of the Inspector General. They're basically the FBI of healthcare. They're in charge of the federal purse and basically that the taxpayer money is being paid correct. Then you have HHS, also agents, which is Human Health Services. You have the FBI, the IRS can show up. The states and the federal government work together in what are known as Medicaid or Medicare Fraud Task Force. So you could also have state officers being part of the investigation or showing up for a visit. The thing that also you have to be extremely worried about is a law called the False Claims Act. The False Claims Act is a law that if you file a claim to the government, when you guys fill out the 1500 form where you swear under oath that everything that you did to submit that claim was according to the law, rules, and regulations, if you violate any law, any rule, any regulation in healthcare, and you submit a claim, that claim becomes a false claim. That means that the government can come after you under that law, under a civil case, and they can show that you violated a law or regulation. For example, you violated anti-kickback, you upcoded, you bill for a code that pays more. They could try to basically bring a lawsuit. It could be a whistleblower lawsuit tied to the False Claims Act, but they can penalize you around $15,000 per claim, and that gets triple punitive damages. So it would be, for example, you have 40 claims times 15,000 times 3, you get into the millions pretty quickly. So a law that really, really affects the provider and that can put you bankrupt in pretty easy. Before they will put you in this program, let's say you pled guilty for anti-kickback or there was some patient abuse or a conviction. The government used to, I'll say 5-10 years ago, put you in the list 3-5 years, sometimes worst case scenario healthcare fraud 10 years. Now the OIG basically is just sending letters, putting you in the OIG for 20 years, 25, 30, which in my opinion, in many cases are ridiculous. You have a right and a due process to fight this process. You will receive a letter, and then you will have 30 days basically to file a reconsideration. Get that letter and don't do anything. Contact a healthcare attorney, contact us. There's 2 things that you can do. You can try to get you out of the exclusion if the government didn't meet the law and the regulations to put you in the list, or you can also appeal the time. It's not the same thing as having 15 years to lowering that to 3. How do you do that? It depends on your case. It depends on the reason that you're put in there. If there's mitigating factors, aggravating factors, etc. Medicare has a 60-day rule, which means that if any of you guys find out, let's say that 3 or 4 years ago, you realize that somebody basically in the office was double billing or billed for services they didn't render. The 60-day rule basically states that 60 days from when you learn about the alleged false claim or the alleged violation, if you disclose to Medicare, to Medicaid, then the government have an understanding that they will not go after you under the False Claims Act. That law that I explained that is extremely damaging. What they will do is that they will ask for that money back. You return the money, we're good to go. So that's extremely important. The 60-day rule, from the moment that you learn of the violation, you have 60 days to self-disclose. You can send a letter and let them know, hey, we found this issue. We're bringing a healthcare consultant, an attorney, will be self-disclosing, and you can take more time. The most important thing that you guys can do to protect your company from the government, from lawsuits, from a potential liability is having a compliance program in place. Compliance is basically your legal defense, right? This is what the government wants to see in your practice. There are 7 elements, right? You have your policies and procedures. You have your policy for HIPAA, your policy for medical records. You have to implement those policies and those standards across the board, or your employees should know about it. They should sign their policies and procedures. And basically, you guys should be in charge of implementing those procedures. Many small practices cannot designate a compliance officer because it's really expensive. But you can definitely have management team, et cetera, providing an overview of billing or an overview of contract situation with your independent contractors or employees, or how you're marketing, or you can bring an outside counsel or a consultant to handle that type of compliance. Always keep lines of communication open with employees. If you want to have a mailbox that people can throw complaints there, you could have an anonymous email. You can go ahead and do that. You should enforce the disciplinary standard uniform across the board. But you cannot, hey, this is my nephew. Because he's my nephew, I'm not going to fire him. I'm just going to give him a reprimand. But then another employee does the same thing and he basically gets suspended. No, it should be the same thing across the board. Normally, how does an investigation start? If it's an audit, you will receive a letter. That letter basically would say, hey, provide me with 30 records of these beneficiaries, give me all these claims during this 2-year period. They will review and they will assess medical necessity under the codes that you build under. If everything is good, then you won't hear from them. If they find an overpayment because they found that claims did not support or the record did not support the claim, then an overpayment process starts where you can have numerous levels of appeal. You first have a first level appeal where you file a redetermination with the contractor. If you lose, then you have a second level appeal under what is known as a QIC, which is a qualified independent contractor hired by the CMS to review the case. And the third one, which is the best, is before a judge. It's called an administrative law judge. That's the audit process. If the government finds during the audit that there may be criminal violation, they will refer the case to the OIG, and then the OIG will take over, and then the OIG will consult with the Department of Justice if they have a case. It could be a civil case under the false claims, or it could go into the criminal side. That's basically how it works. Remember that most likely you're going to talk to the attorneys of the company. Those are not your attorneys. Now, the company can provide you with their attorneys. They're the attorney of the company. If they're not a conflict of interest and your interests are aligned, then there's not going to be a problem. They can represent both parties. The moment that the attorney feels that your interests are not aligned, they have to give you what are known as the option rights, where they have to tell you, listen, I represent the company, communications are privileged and confidential, but the company may waive the privilege, not you. So at that point, you better start thinking about getting your own attorney. The company can pay for it if they want to, and they want to keep you in your graces, but definitely be careful with that. And finally, when you have some illegal activity, for example, you find out that there was some violations of anti-kickback or START law, you're going to say, well, but you told me I have to self-disclose within 60 days. Well, that's not automatic. You have to talk to your attorney, figure it out if there's any other skeletons in the closet, if it's worth it to self-disclose, or if self-disclosing is going to bring more scrutiny. So most likely we want to do a compliance assessment. We want to do an investigation of your practices and where the skeletons may be buried, and then decide if it's worth self-disclosing. The benefit of self-disclosing is that you basically don't have to worry about a False Claims Act lawsuit, which the penalties are extreme, but also it opens yourself for more audits, more investigation, more scrutiny. So with that said, leave it to any questions that you may have, and I'll leave you with Sarah, and thank you very much.
All right. While we're getting Sarah loaded up here with her presentation, we do have a couple questions. So the first question for you, Juan, does the Stark Law apply to non-physician medical providers or to physicians only?
It does not apply to non-medical providers. Normally, what it applies to are going to be MDs, MPs, PAs, people that really can self-refer, because the Stark Law has what are known as designated health service. They're called DHS. Stark doesn't apply to any service in healthcare, by the way. So the answer to the question, it only applies to medical providers that can order the DHS service that is included in Stark Law.
Okay, thanks. And now it looks like Sarah's loaded up, so I'm going to have her start her presentation, then we will get back to questions. So that said, Sarah, I'm turning it over to you.
Hi, everybody. My name is Sarah Badzagalupi. Today we'll be talking about the Florida Department of Health licensure disciplinary process. It's something that you might have to encounter in the future. And I'm actually quite surprised the number of calls that I receive on a weekly basis from providers of any kind. They're actually quite unfamiliar with the process and how it works. That causes a lot of insecurity. And there's a lot of ways that the Department of Health can be implicated or come into your life. You probably only have to deal with them on your initial application and then on licensure renewal every biennium. The goals for today are pretty straightforward. I'm going to go through the process and kind of give you some tidbits of information of things you want to keep out for. And with the goal of going through with some of these terms. Now, Juan just talked about a lot of individual different governmental entities that are federal. Here I'm talking about a single one, the Florida Department of Health. They're just concerned with your license. That's all they're concerned about. But they come into play through complaints filed by a lot of different people, and they are extremely active. That's because we have thousands of applicants every year. And so we have thousands of investigations that come through every year. And investigations can occur also from inspections. The MQA, the Medical Quality Assurance Division of the Department of Health, this past year has shown us they've actually determined over 5,000 legally sufficient cases. Those are cases where there have been Practice Act violations warranting disciplinary action. This is administrative in nature. It is not criminal. It is not civil action. It can come as a result of criminal actions and civil actions, but it is purely disciplinary, focusing exclusively on your license. Of course, that has long-term consequences, which is why I wanted to talk about it. What is a Florida Department of Health investigation? It's the product of a complaint, and the complaint comes from third parties. And the goal here is for the Department of Health to determine whether there's been a Practice Act violation or violation of a particular board rule that regulates your profession. Now, in the state of Florida, we have an overall Practice Act that covers any type of healthcare professional. That's under Chapter 456 of the Florida statutes. But then we have individual Practice Acts that are specific to medical doctors or DOs, as well as other kinds of healthcare professionals. They pretty much mimic each other. The language might be different. Maybe a particular definition within a statute might make or break something. But in reality, the basis here for what would constitute a practice violation is this something that we need to be concerned for patient safety? How does a Florida Department investigation arise? In practice, most of the time, the complaints are filed by the employers or the healthcare entities you have privileges. That's where I see them come most often. Normally, patients that may have complaints about your care, they're going to report that to the hospital. If you instead have your own clinic, then that usually comes up through inspections. Another big one is investigations that come of self-reports. Self-reporting is mandatory in the state of Florida, and it's when you are convicted of a crime in any jurisdiction, regardless of what the crime is and regardless of adjudication. It is also when you enter a plea to a crime, and that plea of guilty or no contest makes no difference. You are required under Florida law to make that report within 30 days of making the plea or being convicted. Basically, this is the Department of Health putting the burden on you to let them know that you may have violated the Practice Act. So that generally will prompt some sort of review. We don't see any type of follow-up investigation on the license, but in a lot of cases, the Department of Health might seek actual disciplinary action. And at that point, it's important to protect your license by contacting an attorney early so that you can do some preventative work in preparation of a possible investigation. The other is the practitioner profile. This is separate from self-reporting. In the state of Florida, you may or may not remember that when you were filling in your license application, you had to report if you were ever involved in malpractice actions or if you ever been disciplined by an organization. That also can include things that from residency or fellowship, and all of those things make it onto your practitioner profile. And you are required under Florida law to make those updates within 15 days of it happening. A lot of people forget that. It's definitely an aggravator and something that the boards look at as a way for the practitioner to perhaps lie or cheat their way through it. So I recommend that if you are in the position of having to update your practitioner profile, that you have that discussion with an attorney. Out-of-state licensing sanctions are reported to the National Practitioner Data Bank. In the state of Florida, normally what we see is that it's the Office of Financial Regulation that makes the report to the Department of Health as a result of just reporting of out-of-court settlements most of the time for malpractice cases. So how do you know you're under investigation? The most common way is you just receive a phone call from the Florida Department of Health. Most of the time, the employer will try to let you know or inform you that they're reporting you. They don't necessarily tell you that consequence of maybe negotiating a termination or a peer review action might result in licensure consequences, but I guess that's perhaps implied. In case you did not know that, anything that might implicate you with malpractice or practicing below standard of care, those kinds of things generally result in Florida Department of Health investigations. Subpoena requests are not necessarily an indicator that you are the subject of an investigation. And the other thing that I wanted to point out is that the Florida Department of Health does not have enforcement power of these subpoenas. And what that means is that they can ask you for records. So you have time, if you receive a subpoena, to contact an attorney and have them review your records. Sometimes they're overbroad. Sometimes people get subpoenas with deadlines that are with the turnaround of 2 days. I've actually had clients that received subpoenas after the deadline. That's all to show you subpoenas by the Department of Health are absolutely important to your respect. You shouldn't ignore them, but there's generally some wiggle room there before you have to respond, and that should tell you contact an attorney. The investigation process in the state of Florida is pretty straightforward, but it's divided into sections. The first division of the Florida Department of Health is the Medical Quality Assurance Division. They're the ones that receive the complaints, and their job is to assign the complaint to an investigator. Investigators have 20 to 45 days to complete their initial investigative report. This is an aspirational deadline, and it's a deadline imposed on themselves, not onto you. What I mean by that is your letter of investigation that notifies you that you're under investigation will give you 20 to 45 calendar days. Report is provided to the Prosecution Services Unit, also known as PSU. That's where the case is assigned to a prosecutor. And unlike inspectors or investigator from the feds, the Florida Department of Health investigators tend to be extremely friendly. They're not intimidated at all. And that's exactly how they should talk. So don't fall for it. Ultimately, the prosecutor needs to have enough information to be able to determine legal sufficiency. And what legal sufficiency really means is this. If I am the prosecutor and I wanted to pursue this case at a formal hearing, which is like a trial, would I have a chance to succeed? If I don't have a legal basis to actually pursue this licensee, then I do not have legal sufficiency. Now, legal sufficiency is not terribly difficult to prove at the investigation stage. The burden of proof for the department is probable cause, so that's not too difficult. What is an investigation like? A letter of investigation will prompt you to send a statement, send a resume, give a call to the investigator. You are not required to do any of those things. There is no mandatory duty to respond to a letter of investigation. That doesn't mean you shouldn't respond. I recommend not to do interviews if you say anything at all, to limit it to written exchange so that there is a record of the exchange and that you do so with an attorney that can help you. Don't necessarily turn everything over. Don't panic. It is good to acknowledge to the investigator that you have received the letter of investigation and that you are seeking counsel, but you do not need to say anything else. You have the right to wait for the production of the evidence against you to provide a response, and that's called the investigative file. So if you make that request for the investigative file, you would have a right to receive it and provide response then if it's more appropriate. Don't jump to make any statements that may end up incriminating you. The next step of the process is what happens at the end of an investigation. And this is when, assuming there is legal sufficiency, the prosecutor will make themselves known to you. They'll reach out, they'll ask if you have any questions. And at this point, if you haven't already asked for the investigative file, there is a time frame by which you need to respond to the investigative file, and it's 20 calendar days. That's normally not enough in most cases, but you can ask for an extension. Most prosecutors do not have a problem including responses that go beyond the 20 days, but they don't have to by law. So if you need more than 20 days to answer, it is good to ask that in writing of the prosecutor and get permission to do that. If the prosecutor is sharing the investigative file with you, that is a good indicator that they believe the case is legally sufficient, because under Florida law, if they do not believe it's legally sufficient, then they don't need to share it with you. Once the case is over, the probable cause panel, also known as PCP, is the entity that determines whether to file formal charges against you. The process can take several months, and that means you are under investigation, but generally with a clear and active license for that period of time. But then the other shoe drops. So if the case is closed, then the case case is dismissed, there are no disciplinary actions against you. If the case is not closed, meaning the panel decided to vote against you for a filing, then that's when you receive an administrative complaint. The administrative complaint has a deadline. It is 21 calendar days. Within 21 calendar days, you have to choose whether to dispute the allegations or not. If you do not do that, then you have defaulted. It is not a good idea to default on an administrative complaint. The option on whether to dispute or not dispute the charges might be self-explanatory in some cases. For example, if you were in fact convicted of a crime, that might not be something you can dispute unless maybe the crime is not something that relates to the practice. Informal hearings are hearings where you do not dispute the allegations of the administrative complaint. That's something equivalent to probably a guilty plea in a criminal case. You still have to prepare for the hearing. You're not required to attend it because arguably there's nothing to dispute, but that is your chance to make your case with the board about what the penalty and what the sanction should be against your license. Dismissal can occur, but I've only seen it happen twice. So I don't recommend you asking for an informal hearing with the expectation that your case will be dismissed. A formal administrative hearing is the equivalent in administrative law cases of going to trial, with the difference that there is no jury. It's an administrative law judge, but it's like a full-fledged trial. You'll be deposed, all the witnesses will be deposed, the evidence will be exchanged, and there'll be multiple witnesses. The administrative law judge will prepare what's called a proposed recommended order. They are determining the findings of fact and the conclusions of law. So they decide what the facts say and what the law says, but they don't ultimately decide what the penalty or sanction on your license should be. They make a recommendation that the board reviews. Ultimately, the board generally follows the recommendation of the judge simply because if they don't, they have to provide specific explanation why, and they generally don't care to do that. Settlement agreement is an informal agreement between you and the prosecution. It can happen in a few different ways. I'm seeing it more and more now as a result of alternative dispute resolution. Now the Department of Health likes to push these cases to the Division of Administrative Hearings as if they were to go to trial, and then schedule them for alternative dispute resolution where there is a confidential third-party judge whose job is to kind of help the parties come to a settlement. If successful, the result is a settlement agreement. If it's not successful, you're going to trial. I wanted to put this slide here for emergency suspension. This can come up at any point during the investigation and at any point after a formal administrative complaint. So I'll leave that here. What are the consequences of a disciplinary action as a result of the disciplinary case? So whether through settlement or through informal hearing, the severity of the violation is what dictates what the sanction is. And the Florida boards follow disciplinary guidelines that are listed in the Florida Administrative Code, but it could be fines. A reprimand is probably the least offensive one in terms of severity. Continuing education is usually included in pretty much every case. Then there are limitations or constrictions on your license, probation, suspension, and finally revocation. Revocation means you do not have a license anymore. You're not precluded from reapplying for licensure in Florida, but that normally is considered permanent.
Thank you all for coming on today. This is almost a two-parter. Next week, we're having another webinar with Chapman. It'll be two different folks that work with Sarah and Juan, and that'll be another interesting one on hot topics in healthcare law at the moment. And once again, thank you, Sarah and Juan, for coming on today. This has been great.
Thank you, Matt. It's been a pleasure. Have a beautiful day.